Namaste. Welcome to the progress review of Gratuity Act. Gratuity is paid as a consideration for past services rendered by an employee, and it is paid as a lump sum. Payment of Gratuity Act applies to every shop and establishment which employs 10 or more employees. Gratuity is normally the last payment. It is paid on the termination of employment of a person. It is always payable to an employee. And the last part of the service may be marked by any one of these three. It may be a superannuation when a person reaches a particular age, or when he retires at the end of his service, or he is retrenched based on the terms of order, and it is payable to an employee in any of these three situations. An employer may be exempt from having payment to gratuity when he establishes his own approved gratuity fund, and this is permitted under section 4A in respect of employers who are employing 500 or more persons and who have got a scheme which matches or improvises over what is prescribed by the government. And in case of gratuity, there is one requirement that a person should have worked for a minimum of 5 years continuously with the employer. It is payable to an employee after he has rendered continuous service of not less than 5 years. Lump sum, 10 or more employees. On termination of employment, it is payable. On superannuation, retirement or retrenchment, where an employer has got 500 or more, he can have his own approved gratuity fund and a continuous service of not less than 5 years. In case of continuous service calculation, maternity leave granted is taken as a part of mandatory service. Gratuity, when it is calculated, it is calculated for every completed year of service and any part of the years of service in excess of 6 months. If it is 5.5, it will be paid for 6 at the rate of 15 days of last drawn salary. Salary means basic salary plus dearness allowance. And the maximum amount of gratuity that can be paid to a person is frozen at rupees 20 lakhs. And it is 20 lakhs or 20 months salary. Whichever is less, the gratuity is payable to an employee shall not exceed 20 months salary. And the gratuity has to be paid within 30 days from the date it becomes payable to the eligible person. Means if it is retirement, from the date of retirement within next 30 days it has to be. If there is a delay in making payment of gratuity beyond 30 days after it is due, the employer is liable to pay interest at the rate of 10% per annum. Maternity leave considered as a part of continuous service. Gratuity is calculated for completed year of service and part in excess of 6 months. 6 months and above considered 1 full year, and for every year it is 15 days of last drawn salary. Salary means basic plus dearness allowance. Maximum amount gratuity is 20 lakhs or 20 months salary, whichever is less. Employer shall arrange to pay within 30 days when it is becoming payable. If the gratuity not paid in time, for the delay, 10% interest is payable by the employer. While calculating the gratuity, average days are taken to be 26 days for working in a month. Every employee has to give a nomination for the proceeds of gratuity as and when it becomes payable in his absence. And that nomination has to be given once he completes an year of service at the end of first year service, and it is filed in duplicate, and there is a specific form for filing the nomination, form F. When an employee who hitherto didn't have a family, if he acquires a family, within 90 days of such acquiring a family, he has to file a fresh nomination. Means his old nomination has got to be replaced within 90 days of acquiring a family. If an employee, if he already has a family and he files a nomination, the nomination has to be in favor of a person who is a member of his family. If he files a nomination in favor of a person who is not a member of a family, such a nomination is void. In the sense, nomination of gratuity has to be essentially in the name of a family member. If there is no family and if he is alone, then he is free to file nomination in favor of an outsider. And for the sake of family, father-in-law of a female employee is a part of the definition of family. 26 days a month, nomination to be filed after completion of an year of service, filed in duplicate in Form F. Within 90 days of acquiring a family, one has to revise the nomination and file a fresh nomination. If an employee has a family, the nomination has to be in favor of a family member. If it is otherwise, then the nomination is void. It needs to be replaced. And father-in-law of a female employee is considered as a part of family. If there is a dispute on the amount of gratuity payable, the employer can pursue the dispute, but before that, it is safer for him to deposit the gratuity with the controlling authority and proceed with the dispute. And the controlling authority may give his decision, and any decision given by him can be appealed, but the appeal has to be filed within 60 days from the receipt of order of the controlling authority. Now there is a limit of 60 days for filing of appeal, but if sufficient cause is shown, the government may condone the delay and it may give time up to another 60 days. Therefore, if sufficient cause is shown, appropriate government may condone the delay in filing appeal against the order of the controlling authority for 60 more days. And an employer has got an obligation to display in Form number U an abstract of the act and rules of gratuity in the premises. And no gratuity which is accumulated in the name of a person can be attached against any decree of court. It is beyond any attachment order. It is a personal saving and it shall remain so. Means no gratuity payable shall be liable to attachment in execution of any decree of court. Court cannot attach gratuity accumulations. And an employer also cannot contract it out. He cannot make an agreement with the employee wherein both agree that the gratuity will be paid below the statutory prescribed amount, because gratuity is a statutory payment which has to be mandatorily paid with strict compliance. The employer cannot make agreement with the employee to pay gratuity below the amount fixed by the Act. Whatever is fixed by the Act has to be paid in toto, and statutory gratuity has to be mandatorily paid. Dispute can be pursued, but after depositing the money with the controlling authority. Any order from the controlling authority can be appealed within 60 days. If no appeal filed within 60 days, if government is convinced of the sufficient cause, it can be given additional 60 days for filing. Employer in Form number U has to display an abstract of the Payment of Gratuity Act in the premises of the factory, and no court order can attach the gratuity accumulations, which are essentially savings of an employee, and an employer cannot have an internal understanding with the employee for paying anything less than what is prescribed by the Act, which is a mandated payment. As regards service of notice, a notice may be served by the employer to the employee or employee to the employer in respect of payment of gratuity. Any such service of notice or communication, it can be by personal service after taking receipt, or it can be by registered post acknowledgement due. The Payment of Gratuities Act does not mention anything about service by courier. If acknowledgement is taken, it might work, it might not work, but it is better to restrict oneself to personal service or by registered post acknowledgement due so far as service of any notice in respect of gratuity or any grievances in that regard. An employer who is already under the Payment of Gratuities Act coverage, employing the specified number of people, if he intends to close the business, he has to give a notice 60 days in advance of intended closure, and the notice has to be sent to controlling authority. It is for planning and required actions from the controlling authority. If an employer intends to close the business, he is to send a notice to the controlling authority of the area at least 60 days before the intended closure. Service by courier is discouraged as it is not specified in the Act. Therefore, better to go by personal service or by registered post acknowledgement due. Any closure of business has to be intimated to controlling authority at least 60 days before the intended closure. Thank you so much. Thanks a lot.